Good morning, all. This directions hearing is in the matter of CFI 020-2023 before His Excellency Justice Thomas Bathurst, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Nasser H. Bajamal Limited. Lead counsel is Mr. Amar Bajamal. The defendant is represented by Nisma Al-Jannahi, advocates and legal consultants. Lead counsel is Mr. Tim Al-Gharawi. Thank you, Your Honor.
Thank you. I have two sets of proposed directions. One of them, I assume, the one in CFI 061 is redundant. Is that correct?
Yes, Your Honor. That's redundant at the moment, as that claim has been withdrawn.
Yes, thank you. Now, can I ask a couple of questions which didn't quite appear for me from the material on file? In relation to what I'll describe as pre-trial matters, what's the position as far as lay witnesses is concerned?
As far as, lay witnesses?
Yes.
We have yet to agree that with opposing counsel, but there are witnesses from both sides, both factual witnesses. And from the defendant's side, they can be obviously present for cross-examination at trial.
What's the position as far as the claimant is concerned, Mr. Amir?
Your Honor, from our side, we had only one witness of fact that we had relied on his testimony at the outset of the proceedings. And then we have the expert that's not a witness of fact. So only one witness of fact from our side.
And how many from your side, Mr. Earl? How many from your side?
I'm sorry to interject. I'm not entirely sure if the defendant filed any witnesses of fact. If I would just like a couple of minutes just to confer with my colleague, because it's been almost 2 years since these were due to be filed. If Your Honor would give me just 2 minutes, I'll check and I will update you right away.
Yes, that's all right.
Thank you.
If I may now answer Your Honor's question, we have submitted two lay witnesses. One, Asad Khan, has submitted a few witness statements, and one, Rami Dogmush, or Dogmush, so that we have two witnesses.
And when were their statements filed?
At various dates, Your Honor. I can pull them up immediately.
Give me at least a rough date.
The first witness, because there are three witness statements, Your Honor. Would you like the dates for all four?
If you can give them to me, yes.
Absolutely. So the first one was the 21st of June, 2023.
Yep.
The second witness statement was the 11th of July, 2023. And apologies, this is defendants. Here we go. The third one was the 4th of June, 2024.
Yep.
And then I believe lastly, 31st of May, 2024.
And they're all from one witness, are they, or from two?
So the first three were from Asad Khan, and the last one was from Rami Dogmush.
Yep. And what about, whilst dealing with you, what about experts? Are you relying on any experts?
Absolutely. There are two expert reports from the same expert. The first is a primary expert report submitted on the 18th of January 2025.
When was the second?
And the second was a supplemental expert report, supplementary to the first one, on the 10th of February of this year, 2025.
I take it that they go to the adequacy or otherwise of the software package.
Yes, Your Honor, as well as the provision of training and the provision of the services in general as well, yes, that the defendant has performed its services correctly and its obligations under the agreement.
Mr. Amir, what's your position?
Thank you, Your Honor. So I'm now told actually that we have only relied on with regards to the facts. It was a witness statement from myself. It wasn't from a witness of fact. And then separately, we relied on an expert report, which was filed in due course. There's one.
When was the expert report filed?
I can find out. Just 22nd of January 2025.
And what does your evidence go to?
Describing the facts and the background of the relationship. My apologies, Your Honor, that there is construction going on the level above me, and
no, I understand. I thought it was at my end, but
my apologies. I might have to change the room if it keeps going on, but I'll carry on for now. My witness statement went about explaining the contractual background between the parties and the facts that led to the disputes, as well as the factual allegations on which the claimant relies.
Do you propose to appear in these proceedings?
No. It's simply a solicitor statement, just it's a vehicle to convey the facts to the court.
I just want to be clear, because I have difficulty permitting you to appear if you're a witness at the same time.
Yes. So I'm not going to give evidence at the trial for sure.
Well,
because the facts were part of the same facts were part of the particulars, and also most of the facts that we rely on with regards to the alleged breaches to the contract are also embodied within the expert report. So as a matter of evidence, everything is already before the court in correct manner.
Well, I just want to be very clear about this. If you're relying on your own witness statement in support of this claim, and if there's anything in contention in relation to it, I don't think it's appropriate that you appear. Now, even though I'd be reluctant generally, if, for example, there's no need to cross-examine you, then there's no difficulty. But if there is, I have a real difficulty about it.
I appreciate the concern, Your Honor, but I believe that if there is a question as to the facts, first of all, under the rules, the claimant is able to rely simply on its submissions in the particulars of claim, and that is permitted under the rules. So to that extent, there isn't any additional facts in my statements that come from my personal knowledge. So we're quite happy to rely only on our particulars of claim and our submissions, because the facts are pretty much the same.
Roger, do you want to say anything about this?
I didn't hear that, Your Honor.
I'm sorry, not Ms. Ralgro. Do you want to say anything about this?
Your Honor, you've definitely picked up on something that was concerning to me as well, and I was going to raise myself at this directions hearing. There definitely is a situation where we envision cross-examining on the witness statement, specifically the second witness statement, I believe, submitted on 7th of June 2024. And so this presents an awkward situation, as you've identified, Your Honor, of the person who's giving the witness statement is the attorney of record and is indeed presenting the claimant in these proceedings.
A very simple solution would be for your client to give the evidence rather than you.
I can take instructions on that. I mean, I don't see this being a big issue, because there was at an earlier stage of the proceedings, there was actually a witness statement from Mr. Bharat, who is a representative of the client, and I believe we should be able to obtain the same statement from him again. Perhaps I will check the file again, and it might be that witness statement is already on record and we can just switch to relying on it, but I don't recall at the moment where was that witness statement filed.
Well, I don't think the defendant would be particularly prejudiced if your client, for example, put on a witness statement in the same form as your present one, but it is a matter which is of some concern to me at the moment.
Your Honor, I would like to go through the history of these proceedings, because the proceedings went through many stages and many delays, and perhaps
I've noticed that. That's why I'm concerned that there be no further hiccups while I'm dealing with this now.
I appreciate that. Perhaps, Your Honor, I would guide you to the fact that there was a witness statement filed by Mr. Bharat on the 7th of July, 2023. So he is a witness of fact, who has described very much the same facts that I've described in my.
Understand.
So I would still like to get instructions and confirm that there's nothing else that we would like to add, but assuming that that is the case, then my apologies. Assuming that is the case, then we wouldn't need to submit any further witness statements, and we would rely on that same witness statement which is already on file, and then we could make Mr. Bharat available for cross-examination during the trial.
Thank you. Could you let the registry know within 7 days whether you're content to rely on that evidence in lieu of your statement, and whether you wish to add anything further?
Sure, thank you.
Thank you.
Your Honor, if I may ask on this point, Mr. Amr has mentioned the 7th of July witness statement that was submitted, in addition to an expert report, I believe, but I can't find record of them on the case management system. Perhaps that is an error on our part. If I could just get confirmation that these were indeed filed and served.
Yes, because actually your client has attempted to respond to the expert report, and so they were served, and some action by the previous counsel was taken in response to our submission, but we're happy to share them with you after this hearing.
Can I suggest this? Within that period of 7 days, each party notify the other of the witness statements on which they wish to rely, both lay and expert, and just point out when they were filed, just so there's no misunderstanding later on.
That's agreed, Your Honor. Another point that we would like to raise is that there seems to be a reference to a second expert report by the defendant, but we haven't been served with that report within the prescribed time. Now, it is one thing, for the parties to refresh each other's memory now, but we say that it should not be permissible to file something that was not filed in accordance with the procedural timeline.
Are you saying you're wishing to rely on a further expert report, Mr. Elgo?
Apologies, Your Honor. You cut out there for a second.
You say you're... sorry. Yes, Mr. Amir.
My apologies. I would like to clarify because Mr. Grawi was not here as well at the time. The way that things went about was as follows. There was an agreed timeline within which the parties were supposed to file expert reports. There were two reports filed, one by each side at the time. However, later on, the previous counsel for the defendant said that they filed a second expert report, which we had no sight of. And now I just heard Mr. Grawi refer to two expert reports. Therefore, I'm pointing out that we don't know what the second report is because it was not served on us within the procedural prescribed time.
Has the second expert report been filed, Mr. Grawi?
It's on the portal, Your Honor. It seems to have been, again, and I should have apologized from the outset regarding the poor case management and lack of procedural proprietary from my predecessors. And hopefully, we'll avoid hiccups moving forward. But one of these hiccups, it seems that the supplemental expert report was filed twice, and it shows on the portal as being filed on the 11th of February, 2025.
That might be true. However, pursuant to the rules and the CMC order, the expert reports were supposed to be served. And we have one issue being that it was never served.
Well, have you seen this expert report?
I have seen one of them. The second one I have not seen because it was not served on us. Now it did come up in some previous context that there was an alleged second report, but we did not take any action to respond to it because it was not officially served on us.
Well, it should be served now. I'm not going. Look, this case, for my reading of it, has had, to say the least, a somewhat unfortunate procedural hearing. I'm not seeking to sheet the blame home to anybody about this, but I'm not going to allow this case now to get bogged down in further procedural or ancillary issues. Now, if there is a second expert's report, and if it's been filed, if for some inadvertence it hasn't been served, I'm going to permit that report, providing that there's no identifiable prejudice to you, Mr. Amir. I'd take a very different attitude if the report hadn't been filed, but it has been, as I understand.
Your Honor, if I may interject and assist the court, one of the things I was going to ask for today is, again, to try and correct the past procedural inadequacies, including, for example, the fact that our expert report doesn't include a statement of truth, and there are a few elements of the expert report that it should contain per RDC 31.55 that it does not contain. For example, the expert referring to the instructions they received from their solicitors. So if I may assist the court and say within within 2 weeks from the date of today, we can file an updated expert report. And to assist the opposing counsel, we will try and provide it in track changes. So anything that's been amended, they'll be able to see clearly, and this will also assist the court.
Very well. I'll permit that. Mr. Amir, if there's any objection to it or it being relied upon, you should notify the registry and I'll have a further case management hearing to deal with it.
Thank you. We'll do that, Your Honor.
We're grateful, Your Honor. Thank you.
That seems to me the best way to go about it. And once you've exchanged your list in accordance with the directions I've given, if there's any objection arising out of any of that, the same thing will apply. I'll arrange a further case management conference. Because as I said, I want to keep this case on the rails now if I possibly can. Now, is there any other pre-trial matters that need to be dealt with today?
We've filed, Your Honor, an agreed timeline, which was agreed between us and the defendant. Now, there is another issue, which is the fact that there are other parties to these proceedings who are not.
That's what I was going to ask. What's the position about the second and third defendants?
Right. Well, the position is that Mr. Growy's client has filed a claim. From what we understand, it's an indemnity claim under a separate contract that is made against Mr. Khan and his wife and the third defendant, which is a defunct company. So in a previous stage of these proceedings, in the very early stages, it turned out that Sharaf Computer Software was dissolved, and
I gleaned that from the public.
Yes, and on that basis they were removed because we had inserted them as a defendant at the outset, and then we removed them as a result of having realized that they're a dissolved company. Now, what happened subsequently by the previous counsel was that they were reinserted this time as a defendant by Belsons. Now, so what I would suggest is I would recommend to Mr. Growy to now agree by consent to have them removed in light of these facts. And with regards to Mr. Khan, he filed what he believed was his suggestion with regards to the timeline, but reading it and him being a lay person, I understand why he didn't understand what he should be filing. So he filed something that looks like a resubmission of everything that was already carried out in the proceedings, rather than a forward-looking document. So the document that is before Your Honor today is the timetable agreed between us and Belsons. Now, Mr. Khan and Mrs. Bianca should have been present today, but they're not. So as far as we are concerned, we are not aware, why they're not here, but the document here today is agreed between only two of the parties, but there is, so Your Honor might need to make the timetable effective by way of directions.
Well, let me get this clear. Sharaf Computer has been dissolved, has it? Is that correct?
My apologies. My colleague just reminded me that it might be that because Belson's discontinued the Part 8 claim, and that was the claim in which Mr. Khan and his wife were inserted, that is, they're not here today because of that. Is that correct, Mr. Grau?
That is why I was a bit confused. We did confirm at the outset of the call that there were two drafts of the proposed timeline, and we did confirm at the start that the CFI 61/2024 was discontinued in its entirety against all defendants. So it's a bit of a moot point now, because now the agreed directions before us are strictly between two parties, being the claimant and the defendant, if I'm not mistaken.
Okay, then I apologize for that. I think I misunderstood. I thought that you'd only discontinued it against our client. So that is clear now. Thank you.
Does anyone have a claim against, or do either of you gentlemen's clients have a claim against Giraffe Computer in these proceedings?
Not from our side, Your Honor.
No, Your Honor.
Well, does that company have a claim against either of you gentlemen's clients?
Not as far as we are aware. As Mr.
When I say
mentioned,
one that's been made, I'm not talking about one in the ether or something, but I'll put it badly, has Giraffe Computer made a claim against either of your clients in these proceedings?
No.
as far as I'm aware, catching up on the case, they haven't engaged at all, probably because they're dissolved.
That's what I would have thought, that if they're dissolved,
Yeah.
unless someone makes an application to reinstate them, that's the end of the matter.
Yeah.
And now, what about Mr. Khan and Mrs. Bianca, if I may call it that? Has anyone got a claim against them? Have either of you two gentlemen?
Well, there was the Part 8 claim, again, erroneously filed and now withdrawn. So no longer in the current in the lead claim, no.
Nothing from our side, Your Honor. We didn't have any claims against them.
Is there any subsisting claim by Mr. Khan and Mrs. Bianca against either of you gentlemen's clients?
No.
Very well.
No from us as well.
Well, what I will do is I'll direct the registry to write to Mr. Khan and Mrs. Bianca and inform them that the directions that I'm going to make today, and indicate to them that this was done on the basis that both you gentlemen, on behalf of your clients, indicated there was no subsisting claim by them or against Mr. Khan and Ms. Bianca, and no subsisting claim by Mr. Khan and Ms. Bianca against them. So if that brings a reaction, so be it. If it doesn't, I think we can safely proceed.
Certainly.
Very well, now, just going to this directions hearing.
Your Honor, if I may, you had asked us a few moments ago if there were any other matters. There is a matter of the defendant wanting to amend its counterclaim downwards. There are, again, issues with the counterclaim that I seek to amend, and a few erroneous claims, namely the claim amount is incorrect and should be lower. As the rules permit,
I don't think the Tribunal will object to that.
Exactly. So, but it must be raised as the rules permit. We are allowed to amend our statement of case if opposing counsel agrees, and which again I believe should be forthcoming, considering the counterclaim amount is being reduced downwards.
You should just serve the draft amendments within 7 days, and if there's any objection, the same procedure applies to the other matters that. Mr. Amir can make the objections, and I'll list it for further case management hearing to deal with it.
Thank you, Your Honor. Mr. Grawi, just to confirm, is it only the amount that you intend to amend?
And the other claims. There, some of the claims were submitted by a layperson, which was Asad Khan, and they were submitted incorrectly. So the counterclaim is now being reduced down to one claim, which is a monetary claim and a significantly reduced figure.
Okay, we'll reserve our position until we see what the amendments are.
That's what I'm not asking you to agree to it now.
Thank you.
Just in principle that we may submit, and we shall. I believe Your Honor said within 7 days of today.
Yes.
Understood.
Now, just going to the end of it, will this case finish within 2 days?
I'll permit claimant to respond, but Mr. Amr, I believe your mic is muted.
Oh, apologies. My apologies. I believe that yes, it can be given the current status, because we only have a claim and a counterclaim, and we don't have a huge number of witnesses. So what I would suggest is to have listed for 2 days with 1 day in reserve.
Do either party have any issue with it being dealt with online?
No.
Now, you've got a start of 11 a.m. GST. Can I ask this, are both you gentlemen in Dubai?
Yes, if Your Honor would like to adjust the time to any time difference, where we can accommodate that as well.
I'd be grateful if you'd agree to start at 9 a.m. your time, which is 3 in the afternoon my time. At least I can get away at a reasonably civilised hour at night, if that's not inconvenient to you.
No,
That's absolutely fine, Your Honor.
Sorry, Your Honor, just to comment. Asad Khan is in the UK, so if it's a witness statement, it will be. We need to consider the time difference, Tim.
We'll adjust to take account of his position. I won't have him getting up before 7 o'clock in the morning. Let's put it that way. So I think we can deal with that.
Absolutely. Your Honor, I wanted to also get clarification on if the expert, the report that we submitted, and opponent as well, are you making an order for the experts to be cross-examined as well, or any joint discussions?
I was proposing, at least at the time of the pre-trial review, to give a direction that perhaps I'll do it now, because I want the parties to agree within 28 days. Sorry, I wish the party, that's unfair. I want the parties to identify within 28 days today the matters relevant for expert determination. And I would anticipate, as a pre-trial review, I will be directing the experts to confer and produce a joint report setting out their views on each of those matters and any competing views which they may have. Now, I don't want to go any further than that today, because the matter still seems to me to be a little bit in flux as regarding what expert evidence there is. But I think the parties can do that. Mr. Rabi, you happy with that?
Your Honor, I would like to clarify an important point here, is that at the moment, the 2 expert reports are really were not prepared in a way that could lead to the experts being engaged in the usual process of them producing a joint statement, because the expert appointed by Belsons did not actually inspect the software. The report is prepared on the basis of certain statements made by Belsons. So in a previous stage of these proceedings, there was an order for the defendant to grant access to the software to the expert appointed by the claimant. And during that process, the other side should have also instructed their expert to inspect and be granted access to the software. However, they did not do that. And what ended up happening is them filing an expert report, which on the face of it is based on the expert saying that certain things were communicated and expressing certain opinions based on what was communicated to him by the instructing counsel at the time or by Belsons themselves. So I don't think that we would have anything productive come out of the two experts speaking to each other now, because their basis of work was completely different.
I'm still going to make the direction I just made, because that doesn't involve the experts getting together. It's rather a prelude to them doing so. But Mr. Argument, if what Mr. Amir says is correct, the expert report is only be as good as the facts on which it was based. If it's simply based on assertions by your predecessor, it's not going to be much help to either me or to your client, I wouldn't have thought.
Well, Your Honor, I mean, sorry.
Go ahead, sorry. Go ahead, sorry.
Well, Your Honor, in response to your query, yes, regardless of whether there is truth to what Mr. Amr is saying or not, the expert report does contain the expert's opinions and analysis and technical expertise on the software, regardless of whether or not they were given access. Our client has given the expert report, reasonable information, video recordings, and the salient data. Now, having said that, in order to assist the court, and again, avoid further procedural hiccups, I had already mentioned earlier in this hearing that we would file an amended expert report within 14 days. If we extend this by a further week to 21 days, then perhaps we can provide a expert report that remedies this deficiency and enables the experts to eventually prepare something that is joint.
I'll give you leave to file such a report within 21 days, but that is without prejudice to Mr. Amir's right to object to it.
I am objecting to that, Your Honor, strongly, because the defendant in this case has been given immense leeway throughout these proceedings with regards to all procedural timelines.
I'm not going back over the history of it. If this report is delivered, and if you can show prejudice in the sense of which cannot be remedied by an appropriate cost order or an undue delay of the trial, then I won't allow it. But I am going to give Mr. Ochami an opportunity to do so. I mean, it should be pretty clear to you by now that I'm treating this as rather a fresh start of these proceedings, because and I don't want to get bogged down in what has happened over the last 3 years or 2 to 3 years or whatever it is. And, but having said that, I'm not going to have your client unfairly prejudiced, Mr. Amir. So let me make that clear.
That is clear, Your Honor. Just for me to understand your directions, are you permitting the defendant to file a new expert report or an amended one, or
I'm giving him leave within 21 days to make it, to put it precisely, to make an application to amend the expert's report in whatever way he wishes. And if you object, and if after that 28 days you object to it, we'll have a further case management hearing where we deal with your objection.
Right. So he's being granted leave to apply, and in the application he will explain what are the changes that he proposes to, or directly file the report.
Precisely. Well, the changes should be self-explanatory from a marked up expert report. And I'll hear argument if there's an objection to it as to whether it should be permitted.
That is clear, Your Honor.
Very well. Well, is there anything else?
Nothing from our side.
So, Your Honor, we're grateful for your stewardship and for granting a fresh start to these proceedings, and hopefully you can avoid any further hiccups.
I'm optimistic. The registry will send out the directions which I've given. If there's any query about them, raise it with the registry and I'll sort them out. But you've got a pre-trial review suggested on the 17th of July. To the extent any of these issues are at large at that time, we'll deal with them on that day. And that pre-trial review will be, as you suggested, at 10 a.m. on the 17th. Bear with me a second. Yes, at 10 a.m. on the 17th of July.
17th, is that because what's on the document?
That's what's in the document.
Yeah, the document, it's 17th. Sorry, I may have misheard. Okay.
No, I'm sorry, the 17th.
Yeah. Your Honor, can I make a suggestion? Because I'm happy to have the, but I don't think that it will be a pre-trial review if the defendant is granted leave to amend their expert report. It is likely that we would want to respond to that, and then that will affect the timeline. So my suggestion is that we keep the 17th of July, but as a further CNC rather, if needed, and we hold off agreeing any further dates until we see how things progress. Because if there is another expert report and we respond to it, I think it's a bit it would be ambitious for us to think that we would still have a trial on the 8th of September or the 11th of September.
I would tend to agree with Mr. Amr.
I think that makes sense, yes. So the only other directions, apart from the directions I've made today, is that I'll set the matter down for a further case management conference at 10 a.m. on the 17th of July.
Sensible.
If I may, I think I might also be out of town on that date, so I might have another time difference issue. So if you could have it at perhaps 2 p.m. UAE time or 12 at least, then that would help me with the time difference.
Alternatively, we could move the date depending on if your vacation or business trip isn't too long. We're amenable to that.
Perhaps maybe we can deal with this. I'll check, and perhaps we'll deal with this over email with the registry.
Yes, my preference would be that it be before or at 12 o'clock, which is 6 p.m. Sydney time. If it's any later than that, I prefer you to move the date.
Right. I think we'll take that into account, and we'll sort it out with the registry.
Thank you.
Thank you very much, Your Honor.
Anything else?
Nothing from our side.
Thank you very much, everybody.
Thank you.
Thank you, Your Honor.